Under cross-examination, PW12 stated that petitioners had 133,000 agents. He was not a party agent at any of the INEC designated polling units or collation centers. None of the 133,000 party agents was called to testify that there was a dispute regarding any collated result at any polling unit, registration stroke ward, local government, state or national collation centers, so as to enable the collation officers at the various levels of collation to activate the process prescribed under Section 64, subsection 6 of the Act. PW12 stated that the petitioners believed they have won the election if the results had been uploaded. When asked about the score of the petitioners by which they claimed to have won the election, he answered rhetorically that how are they supposed to know the score when the result was still being uploaded on the IREF? So this petition is about the belief of the petitioners that they will have won the election if the results had been uploaded on the IREF. Election petition is a serious issue. A petitioner is not permitted to engage in fishing expedition or a roving inquiry, as the petitioners herein did. It is clear from the pleadings and the evidence of PW12 that the petitioners were from the onset engaged in a wild goose chase and inquisitorial adventure. By paragraph 9 of the regulation, a political party has a right to appoint one person as its polling agent for each polling unit, collation center, and one representative at each point of distribution of electoral materials in the constituency where it is sponsoring candidates or candidates for an election. According to PW12, the petitioners exercised that right and had 133,000 party agents in the election. I stated earlier that none of those 133,000 polling agents was called, and not a single one of results forms collected by any of the agents was tendered in evidence. Electoral Act provided a candidate who wishes to challenge any result declared by INEC with a potent material, which are the forms on which results are entered, signed by the first respondent officials and party agents, and a duplicate copy of it is given to the party agent. Any serious candidate ought not to depend on INEC for materials to prosecute his petition. By Section 167D of the Evidence Act, the failure of the petitioners to produce election result forms collected by their agent raises a presumption that if those forms had been produced, it would have been unfavorable to the petitioners. The first respondent in their pleadings and evidence through DW1 stated that the delay in uploading the results from the polling units to the IREF was due to a technical glitch which occurred on their transmission system, which was rectified within a few hours. All that the petitioners could do was to bring a PW1, a member of the second petitioner, who claimed to be a software engineer and an employee of Amazon. She had the temerity and the audacity to claim authorship of a document, a word of which does not belong to her. The first respondent never claimed that the glitch occurred on Amazon Web Services. It is obvious from PW7's evidence that the petitioners did not understand the explanation of the first respondent, or were just fixated on their belief that they won the election without any cogent and credible evidence. And they did not even bother to place any such credible evidence before this court. Were they expecting the court to go and gather evidence from the street or from the market, or to be persuaded or intimidated by threats on social media? That is not the way of the court.